Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Singh. To my left is Judge Brennan. And together we are your panel on the 5 cases we are hearing today. If you're paying attention, you realize that one case is off the list. I'm going to assume, with the exception of one pro se party who's arguing today, you're familiar with the rules of the court, 15 minutes per side. No opportunity for rebuttal. Because 15 minutes generally is not a great deal of time, we urge you to the extent possible to cut to the chase. And to the extent you don't do that, we'll be happy to help guide you with questions. That said, if you feel like you've made your points, there is no shame in sitting down, or as one of my former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day. That is Commonwealth versus Smith, 2022 P-120. We'll hear first from Attorney Margison.
Good morning, Your Honors. May it please the Court. My name is Jenny Margison. I'm here on behalf of NATACHA Smith. Today, the main issue that I would like to address is the Commonwealth's sole witness testified to operation, which was an ultimate issue that they shouldn't have. And then if time allows, I'd like to just address the sufficiency briefly. The statements, the vehicle was in operation and she was operating the vehicle were improper because operation is an element with a precise legal meaning, and it's a legal conclusion, and therefore it's inadmissible.
Now, if I recall the briefs, there was no objection, correct?
That's correct.
So we're limited to substantial risk analysis.
That's correct.
Okay. Can you name a case, including Canty itself, that actually reverses on so-called Canty grounds?
I'm not sure I can off the top of my head. I do believe that the language in the cases support that it's not an appropriate, there is one, I'm sorry, is it Honda Motor Corporation? Yes, that, negligence, they use the term negligence, and they say that that must be left for the jury. That's Pupolo versus Honda Motor Corporation. I believe that that case supports that conclusion.
May I ask, in this context, how is this different from the officer saying she was under the influence of alcohol? Or, in my opinion, she appeared to be under the influence of alcohol.
So I think Canty addresses that very clearly, that intoxicated is a very familiar term that people in the general public are aware of.
What if he had said under the influence? In my opinion, the defendant was under the influence of alcohol.
I mean, that's not the facts in this case, but I do think that that given the fact that people do understand the idea of intoxication much more familiar, with a lot more familiarity than operation, I think that it's very clear that we don't allow witnesses to use shorthand to get to the facts of a case. When someone says, I was assaulted, they in fact mean that they were battered. They don't mean that they were in fear. They typically, when they say on the stand, you know, I was assaulted, they mean I was hit by someone. And if that were the situation, the witness would, the prosecution would then say, so tell me what happened, please. And it would be elaborated. In this case, there were no actual facts that were presented to the jury. It was just simply the conclusions.
Under different circumstances, do you have any issue with the officer saying, I saw her driving?
So I believe that, well, driving would be a fact that
And what if she was in fact driving? He said, well, she was operating her car down Main Street, and the car was in motion. In other words, is it specific to the facts of this case where the car, where we're really talking about technical operation as opposed to what we perceive as obvious operation? No, it's okay.
I don't think that it's necessarily specific to the facts of this case. I believe that because the element operation is a necessary element that has a legal meaning, that's what differentiates that from maybe being intoxicated or under the influence, or someone saying, I saw the car driving down Main Street. He was going west. You know, you see the cars in motion where people don't necessarily understand that operation has a specific legal meaning, and simply sitting in your vehicle with the keys in the ignition and your seatbelt on is technically operation. So this case was, from the very beginning, a clear operation case.
Counsel, the statement, if I remember this correctly, was the car was in operation as opposed to she was operating the car. Does that make a difference?
I don't necessarily believe that it does. I think that the issue is with the term operating. You're reaching that conclusion for the jury. You're telling the jury what to find, and you're removing their independent analysis by using that term and not providing specific.
But the judge, tell me if I'm wrong, instructed the jury that they were the determinants of the facts. So how is the witness taking that away from the jury?
There were no real facts submitted to the jury. The Commonwealth says that the term operation is a summary description. I do believe that the terms on and running would be considered summary descriptions, similar to the case law that says that you can see a vehicle, you know, a motor car sway, like the Plowman and the Cushman cases. I think that those.
But I'm confused because the officer said the car was running, and I believe he also said the car was on, and as you point out, he said the key was in the ignition.
Right, and I mean, the Commonwealth admits that their sole witness was very clearly impeached on the fact that the key was in the ignition. That was a factual.
That's your other issue.
It is a separate issue.
But with the officer having described this in detail, why he believed the car was in operation, why does it matter, especially on a substantial risk basis, that he might have also said the car was in operation?
I think it matters because when you remove the in operation statements that the officer repeatedly makes, the remaining testimony of the officer is not really factually based. It's a couple of legal conclusions and summary descriptions that are not supported by observed facts, as the case law requires. And then on top of that, the officer's testimony was weak at best, clearly impeached. So he was either.
What do you mean by impeached in this context? Because your sufficiency argument is based on that there was, you know, pure 100% contradiction.
Correct.
And putting aside the fact that keyless fobs typically have a key in them, as I believe came out on either a cross or redirect in this case, couldn't the jury have concluded that he was correct that the car was running, even if he, for example, didn't recall accurately whether there was a key?
I do think that the jury can make reasonable inferences. They're very obviously allowed to do that. But in this case, in order to reach that conclusion, the jury has to pile inference upon inference upon inference to get to that conclusion. The testimony was the keys were in the ignition. He was very adamant that the vehicle keys were in the ignition. That was a factual impossibility in this case. So the officer was either guessing or completely wrong with his testimony, right?
Isn't the testimony the vehicle was on? Why isn't that enough?
I think that is a summary description. It doesn't provide any actual facts that support that. It doesn't say there was exhaust coming out. The engine was making noise. There's no fact to describe that.
Why isn't, I hear what you're saying, but why isn't that fodder for cross-examination? Why did you think the car was on? Oh, I heard the engine running, or.
I mean, I believe that the defense counsel sort of did reach that by saying, by getting to that, and the officer's only replied statement was the keys were in the ignition. That was how he knew that the car was on. That
Why was the jury not free to reject the defense investigator's testimony? If they chose,
I mean, I'm sure that they were free to reject that testimony.
Right. So if they rejected the testimony that this is a keyless car, that there's no key operation, where does that leave us? And how do we, I'll just leave it at that.
Why wasn't there an alternative path that the jury could have driven to? Namely, that this car was found parked askew on the road, at least partly on the road, and your client was found seemingly intoxicated in the driver's seat without anybody else there. So for the jury to have rejected that she had driven there in her current state, it would have had to conclude that she drank while she was parked. And given that the car was seemingly left, again, askew in the road, couldn't a reasonable fact finder have concluded that, no, she drove there in her current state?
The name of the case escapes me at the moment, but I do know that there are cases where there's a vehicle that's been in an accident, that the officers arrive on scene, and that the individual is standing there and says, I wasn't driving, and that's not enough. The fact that you can't make that inference that that individual drove that vehicle into that.
I don't know which case you're referring to, but I suspect there may have been multiple potential drivers there. There's a case that I cannot remember the name of that includes words along the lines of the jury didn't have to assume the car was dropped there by a helicopter.
Yes.
Why isn't that case more similar than the multiple driver cases?
I think there's another case that says that there's no, I agree that the jury doesn't need to believe that, the car was dropped there from outer space, I think the case says. But there's no way to know the condition that she was in when she got the vehicle to that location, and there's no way to know for sure that she's the only individual that was in the car and that she, in fact, drove the vehicle to its current location. It's parked outside of someone's house. It is askew, as was described by the officer, but it is halfway in the parking lane, and there's 2 McDonald's bags in the car. So it's equally fair to assume that there were 2 individuals there.
This is, I don't think, the case, and I'm not sure, I'm pretty sure we haven't gone down that road, but what's your assessment of the key fob issue? At what point does it become operation? Because you have cars now, right, where you sit in the car and it kind of turns on automatically. We actually have cars that operate without an operation.
Right.
Any thoughts on where we ought to go? I know it's probably off topic a bit, but it's just as I read it, it struck me.
I also had sort of thought about that, but
Right. Used to be lights on. Well, lights on, and you get in your car, your lights are on. You walk near the door, and it unlocks.
And the lights are on, right.
Yeah.
I know. I think that it is becoming a more foggy issue that the court is at some point going to have to address more clearly, because there are vehicles that don't even have a key anymore. And most of the push-start vehicles don't have a place where you could even put a key in. You just have to touch the fob to the little spot on the dashboard if, for some reason, it doesn't recognize that it's in the vehicle.
Tesla's cell phone, right? I think some Teslas, you just work it on your cell phone.
Yeah, and
Right.
BMW does too. You can turn it on, you can shut it off, lock it. You don't even need a key anymore. They have like a card. I mean, I think that technology is expanding, and it is at some point going to need to be addressed by the court, but I'm not sure that this case it reaches that extent. I mean, the vehicle was parked. But I think that if you remove the issue of operation, the remaining testimony regarding that element is insufficient. It would be my remaining argument. So if there are no further questions, I would rest to my brief.
Thank you very much, Commonwealth. Council.
Thank
We'll
you,
hear
sir.
from the Commonwealth. I got ahead of myself.
Good morning, Your Honors. Brennan Hunt for the Commonwealth, and may it please the Court. The Commonwealth respectfully asks this Court to affirm the conviction below because there is sufficient circumstantial evidence to support a reasonable finding from the jury that the car was in fact in operation by Ms. Smith while she was under the influence of intoxicating liquor. There's sufficient facts that we've previously discussed that address this very issue that were presented during trial. Those include that the car, as previously discussed, was parked at an angle, straddling the fog line, coupled with the fact that the defendant believed that she was in her home city of Hyde Park within Boston, when in fact she was told that she was in Braintree. Additionally, that the officer testified that the car was parked there with its lights on, it was running. The defendant was asleep alone behind the wheel of her SUV. The testimony that the car was running, quote, her car was on, and the testimony that the defendant was able to utilize the electric windows to her left as testified by the officer. Additionally,
So can you pick up on the, and again, the question I just asked, which is, again, my car, I can push my windows up and down once I turn it off. Hit the button and it still go up and down. Am I still operating the car?
under the precedent, I would suggest that if your key fob is within the car and you are intentionally manipulating mechanics of the car to set it in motion, then it could be found by a jury to.
So the moral of the story here is don't drink in your car? I don't mean to be flip, but right? I mean,
It's probably a good rule, but
It's a
if
great,
you're parked in, again, parked on the side of a road that happens to be, and you know, is that
I
is
believe,
that operation is in the context of this statute?
in context of the statute, it would have to be looked at in context. I mean, there would have to be sufficient circumstantial evidence to accompany the fact that you were just drinking in your car at that point to warrant the finding that it was operating while you were under the influence. Additionally, Attorney Marginson speaks to operation being not a word of summary judgment. However, I disagree. The prosecutor was asking the officer a chain of questions, asking, could you, what do you mean by running? The officer responded that the vehicle was on, the vehicle was in park, but the vehicle was in operation. Operation being an adjective in this case that has significance in context, being that he was summarizing exactly what he had
But
previously said.
he also did specifically say the key was in the ignition and I believe turned. Putting aside the question whether the jury could reject the evidence that this was a keyless ignition, what is the import of the possibility that there was a key inside the electronic fob? And by that I mean, what are the chances that the driver would have to rely on the key inside the fob?
So speaking in that particular situation, when an individual enters their car with a key fob, it's keyless ignition. If the key within the key fob, if the key fob isn't working, it's not responding to the vehicle, they would have to remove the key out of the key fob and manually insert that.
No, I understand the theory. What I'm saying is this a fail-safe that no driver realistically ever has to use? Or is this something that commonly is used when that darn key fob isn't working.
I think the jury could find under common knowledge that it's a backup, it's a fail. You know, if your key fob isn't working, the jury could reasonably conclude that they could use that key. But in this case, there was no discussion that she had removed the key. So does that?
Well, I guess I'm just pressing the theoretical point of, is it enough that it is a possibility that there was actually a key, or does there have to be some evidence that there's a decent chance she was using the key as the officer explicitly testified? I mean, you said the jury could use their common knowledge. If I were a juror, I could have relayed that I have never used the key inside my key fob because I've never had occasion to.
Right. In this situation, in this case, I believe there was no direct testimony that the key was being used outside of the key fob. The officer, when he was testifying, did state that the keys were in the ignition. The prosecutor further asked him, "What do you mean by the car was running?" And that's when he concluded that the vehicle was on. Additionally, going to the point that no objection was made, I think that is some indication that the tone and manner of the testimony did not appear at trial as prejudicial as it does here. I believe that speaks volume as well, and it doesn't, moreover, it doesn't violate any evidentiary rules. The evidence rule 704 does state that you can have an opinion that
would you
touches on
agree
the
that
ultimate issue.
just as a practice, it's probably not a great idea for a witness to parrot the language of the statute?
Not necessarily, because I mean, adjectives, you know, they have significance in context, like I said earlier. So if a witness, excuse me, is testifying on the stand and they happen to use an adjective that is directly within an element of the statute that the defendant is being charged on, it doesn't foreclose him of using those summary descriptive words.
No, but say if trial counsel had been particularly on the ball and wanted to object and had stood up and said at sidebar, "Your Honor, I object. They used the language of the statute. I want a curative instruction that says that it's in the jury's province to determine what operation means." Wouldn't the judge have been entitled at least to offer such an instruction?
Yeah, I would agree in that case that would be okay. And in this particular case, the judge did offer instruction at the end of the trial to the jury that they can choose to accept the full testimony of the presented witnesses, and that they have charged to determine operation, whether the vehicle was operating. If there are no further.
Yeah. Hearing none, thank you very much. The case is submitted.
Thank you.
Our second case of the morning is 2022 P326, Commonwealth versus PALLAS. And I would remind the parties that the case is partially impounded, so please do not use, for example, names of any victims.
Morning, Your Honors. May it please the Court. My name is Joseph Keneally, and I represent Mr. Pallas for purposes of his appeal. Your Honors, I would submit that this is, in some respects, not a complicated case. I would suggest that this case is, this Court's decision in Commonwealth versus Spring essentially compels a reversal of the judgment in Mr. Pallas's case. all the years I've been before this court, I have never encountered a set of trial facts that is as closely aligned to the facts of a controlling case as this case is the Commonwealth versus Spring. I mean, if you made a Venn diagram of the two sets of facts, it would essentially be like one circle. Even the witnesses were the same witnesses, were testifying in a similar way about the case. However, I don't want to go into an exhaustive explanation of the similarities of the two cases. That was a horse beaten dead in my brief, and there's no reason to get into it unless this court has any questions on it. But I would like to maybe stress a couple of the differences between Spring and between Mr. Pallas's case, because I think that this case makes a more compelling argument for reversal than did the Spring case for a couple of reasons. First, in Spring, the error was not preserved at trial, and the court evaluated the case under the substantial risk of miscarriage of justice or ineffective assistance to counsel claim. In this case, however, and as the Commonwealth acknowledges in their brief, the error was preserved at trial, and therefore it isn't, the review here is entitled to a standard more favorable to the defendant, to the respondent, to Mr. Pallas. Additionally, the case against Mr. Spring, I would submit, was stronger for the Commonwealth than the case against Mr. Pallas. Mr. Spring had twice as many victims as Mr. Pallas did. And in Commonwealth versus Spring, there were two qualified examiners who testified that Mr. Spring was sexually dangerous, whereas in this case, there was only a single witness for the Commonwealth who testified that Mr. Pallas was dangerous. So the bottom line here, I would suggest, is that if a new trial was warranted in Spring under the substantial risk or ineffective assistance claim, it's undeniably warranted here, where the error was preserved, the standard of review was more favorable, and the government's evidence was far less compelling than it's far more compelling than it was in this case. Now, as to Mr. Pallas's case itself, the issue that is involved here is what kind of instructions are necessary when an individual at one time had been guilty of committing contact-based offenses, but over time has, as the court referenced in the St. Martin case.
How important is it that these things happen sequentially? If these had not been the facts and they were mixed in contact and non-contact, why wouldn't you still have an argument that
I think you would.
Suave-based instruction was
I think that you would. In fact, in Commonwealth versus Walker, which is 476 Mass 1017, a 2014 case, Mr. Walker's governing offense, if I remember correctly, was a mixed contact, non-contact offense. So Mr. Walker was essentially was an exhibitionist whose latest offense was a contact-based offense. And in that case, the court still reversed because there was no suave analysis undertaken. So it doesn't matter completely whether or not there's a de-escalation necessarily. What matters is whether there is a theory of the case that would allow a jury to conclude that a defendant may commit a non-contact-based offense. It doesn't matter if what the pattern was necessarily.
If I can paraphrase what you're saying the instructions might be required in either context, but that your client's context is stronger because of the particular sequence in which it happened here.
Yes, because there is evidence of de-escalation. It was required in Walker. In fact, I would suggest that if you looked at Commonwealth versus Rodriguez, which was an unpublished opinion, the suave instruction was given in a case where there's contact and non-contact based offending. There's another case which wasn't cited in the briefs, Commonwealth versus LaFlamme. In fact, I think that Justice Singh was on that panel where it was a jury waive trial and there's contact and non-contact based offending, and the court said that they're going to assume that the trial judge had conducted a suave analysis in determining whether the defendant was sexually dangerous. So there are tons of cases out there that suggest that it's important to conduct a suave analysis, whether it's in jury waive context or an instruction to a jury. And I would submit in Commonwealth versus Walker and in Commonwealth versus Spring, of course, the court has said it was reversible error not to instruct on that.
The Commonwealth suggests that the essence of the instruction was given.
It was not, Your Honor. The essence of the SWAV instruction is that if you're going to commit a non-contact-based offense, it must be the kind of offense that will instill in a victim a reasonable apprehension of being subject to a contact-based offense. None of that language is in the judge's instruction. And in fact, we know the judge didn't instruct on what a menace means because he literally said, I'm not going to instruct on menace. That's in the record appendix on page 271. He specifically said, I'm not going there. And that became a huge problem, I'd submit, because the jury came back and said, essentially asked the judge a question, what kind of sex offending is necessary for, what sort of predictive of sex offense would Mr. Pallas have to commit if we're going to find him sexually dangerous?
Wasn't the question specifically just, can you define sex offense?
Yes, it was, Your Honor.
So we don't know, well, except they did make a reference to the written instructions. Sex offense as mentioned in page 16 and 19.
Yes, but there's only one reason they were wondering what a sex offense
Well, what's
was.
on page 16 and 19?
Of the...
The jury, the jury question
You got me
was-
there, Your Honor. I can't
Because
answer.
I'm sorry, I couldn't find in the record where the written instructions, they were referring to the judge's written instructions that they got.
Yes, they
I didn't
were.
see that.
And I'm sorry, I can't answer that.
That gives you some context as to when they asked about sexual offense,
Well,
as used where in his instructions?
perhaps.
Do you know, first of all, whether the written instructions are in the record appendix?
They are not in the record appendix.
Were they
I don't know if they're
marked as
I
an
don't know if-
exhibit
I
for
don't know if they're
identification?
I don't know if they're marked for identification. I mean, generally, I don't have the record appendix upon me. It's like 1,400 pages. I wish I did now, but I don't know if they were introduced or marked for, they generally are, but I cannot say. However, I think the important thing,
No, but if I can, just before we leave this point, they are part of the appellate record regardless of whether or not they're in the record appendix.
yes,
But that begs the question of
whether
whether
there
as a
was some
practical
type-
matter, we can retrieve them.
Well, I think the issue that you need to consider here is that they could only have been asking for one reason, because there are two ways the definition, the term sex offense is used. One, in the first prong, was the defendant previously committed of a sex offense to be eligible for commitment?
And that's stipulated.
Stipulated. They didn't have to think about that. The only other reason the definition of sex offense comes up is what sort of predictive offending must the respondent be likely to commit in order to be sexually dangerous. And I would submit to you there are only two ways that you can do that. One, it has to be a contact-based offense, or two, it has to be a non-contact offense that will instill in a victim a reasonable apprehension of being subject to a contact-based offense. Those are the only two ways. Possession of child pornography is not one of those ways. The court said in spring it's not one of those ways. And when the jury is asking what sort of offending, what a sex offense meant, it was in the context of what is he going to do, okay? And at that point, counsel, who had been arguing, possession of child pornography is not enough. You need to give the menacing instruction. You need to give the suave instruction. The judge didn't do it. In fact, it was worse. What he did was he said, he gave a list of everything enumerated in the statute, and we know that that was wrong. We know that if you instruct the jury that possession of child pornography, the likelihood of possessing child pornography is enough to render someone sexually dangerous, that's contrary to what the law is. It's contrary to Spring. I'd submit it's contrary to Commonwealth versus Walker and Commonwealth versus Suave. But he gave that instruction, and lo and behold, 8 minutes later, the jury comes back, and guess what? Mr. Pallas is sexually dangerous.
What was the evidence, the testimony concerning what offense he's likely to commit? Was there
Well-
specific testimony regarding?
Well, the important thing I think that should be kept in mind is that no one testified that Mr. Pallas was likely to commit a contact offense. Not a single witness. Even the Commonwealth's witness, Dr. Bell, said he couldn't tell one way or another. And in fact, he got the law wrong. He said it didn't matter when we know it matters. But he said he couldn't say one way or the other. There are the other qualified examiner, Dr. Jaw, says he did not believe that Mr. Pallas would commit a contact offense. Dr. Plod said he did not believe Mr. Pallas would commit a contact offense. In fact, Even the judge, I think it was on page 271, said he didn't think this case looked like a case where Mr. Pallas was going to commit a contact offense.
But if you're correct that there was no evidence that he was likely to commit a contact offense or a non-contact offense likely to instill reasonable fear of a contact offense, why aren't you making a sufficiency argument?
Because the evidence was sufficient, Your Honor. I think that the every time you have a case where there's prior contact offending in an individual's history, if you look at it in light most favorable to the Commonwealth, yes.
Even without an expert opinion on that issue?
Yes, because Dr. Bell didn't say there's no evidence he would commit a contact offense. He said it could go either way. And under the sufficiency standard, under Lattimore, that should be enough.
But why doesn't that contradict your earlier statement that there was no evidence?
Well, perhaps I was
Caught up in
indulging in hyperbole a little bit. Yes, there was some evidence, but it was as the court said in spring. There was some evidence, but it was weak. And the overwhelming evidence was that this individual was going to engage in probably attempting to possess child pornography. And the jury was wondering what kind of I would submit the jury was wondering what kind of offending he would commit if he was out. And the judge said, yeah, sure. Possession of child pornography is enough to render one sexually dangerous. And less than 10 minutes later, we have a verdict. I think it's a clear case that that this bad instruction over.
Do you want any time for your other arguments?
The only thing I would suggest here, Your Honor, is that the closing argument from the Commonwealth, the last thing that he left the jury with, where he went into a lurid description of a cartoon that was allegedly drawn by Mr. Pallas, didn't involve children, didn't involve any sort of exploitive content. It was just lewd and perhaps distasteful. And the Commonwealth pulled this out and described it in lurid detail for purposes of just giving the jury a bad taste and giving them a reason to go in a particular direction. It had no evidentiary significance. It didn't mean anything. It didn't speak to his likelihood to reoffend. It had nothing to do with children. He was diagnosed with pedophilic disorder. It had nothing to do with any of that. In fact, it wasn't even considered to be a sex offense. It was just a dirty cartoon. And the Commonwealth, to wrap their case up, said, here's what I want you to remember as you go back to the jury room to deliberate.
There was no objection, correct?
There was no objection. I think there was one objection to one of the issues that were raised in the brief, but in large part, there was none. I would just point out, this is over and above. It may not have been by itself sufficient to overturn the verdict, but I think there's plenty of reason to do that anyway. But I think that that's something that it happens too often, and it needs to be recognized when it happens. And I think that that's something that this court should consider when looking at the case as a whole and determining whether or not Mr. Pallas is entitled to a new trial on this case. So unless there's anything else, Your Honors, I'd rest.
Thank you very much. We will hear from the Commonwealth.
Good morning, and may it please the Court. Danielle Borges on behalf of the Commonwealth. Your Honors, in this case, Judge Reardon's jury instruction did comport with the Suave Faye Walker line of cases, and it's worth mentioning that he did not have the Spring case to consider where it came down in 2018 and this trial was in 2017. But it's the Commonwealth's argument regardless that Judge Reardon did not need to give the menace definition when the Commonwealth was relying on the defendant's prior history of contact and non-contact offenses in determining his SDP status.
I'm having a hard time understanding the Commonwealth's argument, and much of your brief reads almost like you're responding to a sufficiency argument. For purposes of determining the propriety of the refusal to give the requested instruction, we are to look at the evidence in the light most favorable to the respondent. And here, why isn't the respondent correct that this jury may well have found him sexually dangerous based on the likelihood that he would continue to seek out child pornography. And if that's the case, why wasn't the respondent entitled to the specific instruction that he requested?
Sure. So first I would point to the Curlew case, which was unpublished, but that stood for the proposition that this menace definition was not required.
I'm sorry, I didn't hear, what case did you say?
So it's Curlew.
Yes, okay.
There was no requested instruction in that case, right?
I believe the argument on appeal was made that the defendant was entitled to that instruction.
No, I understand the argument, but the argument is along the lines of that the judge erred by failing sua sponte to give the instruction, which is a very different context from rejecting a specific instruction that was put in front of him.
Sure. So I think in this case, too, where the Commonwealth wasn't only relying on a theory that the defendant had commit non-contact offenses in the past and would further commit only non-contact offenses in the future.
Why isn't that a sufficiency issue and not a jury instruction issue?
Because I think the jury instruction is only warranted when the evidence presented at trial would then lead to a theory that the defendant would only commit a non-contact offense.
Doesn't Spring reject that explicitly?
So I think with Spring, there's a huge difference in some of the factual elements of the case, which is why I think that they're not as on point as it seems to be at face value. And so just briefly, I'd like to discuss that in Spring, there was a significant body of evidence that the defendant had chosen to look at child pornography in order to avoid engaging in contact sex offenses. In this case, in the defendant's 2016 interview with Dr. Bell, he explicitly said he was glad he got caught with the child pornography because it would have led to other charges of him doing something to someone. So I think that's the defendant openly admitting that he himself was fearful of committing a contact offense. And the jury heard all of this. The jury heard this testimony from Dr. Bell. They were able to see Dr. Bell's report when they were deliberating. And so I think it shows it's reasonable to believe that this defendant was likely to commit contact offenses if he was not confined to a secure
So
facility.
that sounds more like an argument going to whether he was actually prejudiced. But do you agree that it was error?
I think given the overwhelming evidence of the defendant's prior history and the evidence that he was likely to commit a contact offense in the future, Judge Reardon had all of that to consider when he was explicitly deciding to decline to give that instruction. And I think at the time with the case law he had, he made the proper decision.
Do you agree, though, that that the way that the instructions that were given, in addition to the answer of the jury question, allowed the jury to come to a conclusion that he would be considered dangerous if he simply was likely to engage in more child pornography possession?
I don't think the instruction or the answer to the question was a definite lead for the jury to automatically.
It allows them to come to that conclusion, correct?
Well, first with the jury question, I would say that they did only ask, I think you mentioned earlier, they only asked for a legal definition, and they were just given the legal definition, I think, directly from the statute. And so,
And again, but their request was framed in terms of sexual offense, as you discussed on this page and that page of your instructions. And given that the first time sexual offense is mentioned, that's stipulated to, they could only be referring, don't you agree, they could only be referring to the predictive offense?
yeah, I think it's difficult to make assumptions about what the jury was thinking about in deliberations. I understand where you're coming from, and I think it's definitely possible, but I don't think we can definitively say this is what the jury.
No, we certainly cannot definitively say, and there are lots of cases that caution against appellate courts making those judgments. In this context, though, isn't there some force to the respondent's argument that when the jury got the answer to their question, they almost instantaneously found the respondent sexually dangerous?
Yeah, it's definitely a possibility. Like I said, we don't know what they were thinking about. They could have been stuck on one question, they heard what they needed to hear, and that's what led them to make their decision.
But could they have been confused about all of the other contact offenses, whether they constituted sexual offenses or not? I mean, this isn't an exhibition sort of case. aside from the child pornography possession, everything else was pretty obviously a sexual offense.
Yes, it's possible, and it's possible that could have been their line of questioning, but I think with the defendant's prior history and also with the porn possession, sorry, strike that. Just another observation I think they were able to make is that unlike Spring, where he had been looking at the child porn, he hadn't had any contact offenses, and I think it was 22 years, and that similarity is brought up in regard to the defendant not having any contact offenses for 25 plus years. I think it's worth noting that even the defendant's experts stated that in those prior decades, he had only been unincarcerated for about 4 years of that time. So I also don't think, and again, the jury's hearing all of this.
Can I say, you're making some excellent points. As counsel pointed out, however, there are also some differences with Spring that cut the other direction in terms of whether the error was preserved and the fact that in this case, there was only one QE who thought he was sexually dangerous and the other thought the opposite. So why isn't this, at least in some respects, a stronger case than Spring?
I mean, it's a valid point to make that there was only the one QE. I think that in regard to the idea that the QE was possibly, unsure whether the defendant would commit contact versus non-contact in the future, his job only was to determine whether or not there would be an offense committed. He was asked, I think, numerous times on cross-exam, well, can you say contact, non-contact? And he explicitly said, that's not what I'm asked to do. I'm asked to just determine whether there would be an offense, and that's what he did. So there are definitely differences from Spring that perhaps sway in the favor of the defendant, but I think the stronger differences in the evidence that the jury heard and just the strength of the evidence overall is what led Judge Reardon to decline to give that instruction.
Can you identify any meaningful difference whatsoever between Judge Broussard's jury instructions in Spring and Judge Reardon's instruction here?
Off the top of my head, I don't think I'd be able to tell you the exact differences. And I mean, I could definitely take a look and then supply the court with
But there's nothing in your brief that would say, oh, this is why this instruction was better, if you will, for the respondent.
I don't think there's any reference of that in the brief, no.
Okay. I mean, they both effectively went from the model jury instruction.
Correct.
Without the menace.
Correct.
Now, you made a comment a while ago saying that the instructions were correct based on the case law at the time. You may well be correct, but isn't that beside the point, given that the case is still live, the issue was preserved, and we're answering whether or not the instructions were correct?
Sure. And I think to that, I then would point to this court's reasoning in that unpublished Curlew case, because that did come out after Spring. And in that case, the court declined to give the Spring instruction and said that that was okay. It wasn't prejudicial error.
Where it was not requested.
It was not requested, yes. So I definitely appreciate the difference. But just in light of the argument, I would say that's probably the Commonwealth's best support for this proposition. Briefly, as discussed, even assuming this requested instruction was warranted, the Commonwealth would argue there was no prejudicial error from the failure to give it. Not to go into what was listed before, but the jury heard extensive evidence of the defendant's history of sexually assaulting children. They heard Dr. Bell testify it was his professional opinion that he would commit a sexual offense again. They heard that probation was not a protective factor, given the defendant's history of violating probation. And again, they heard the testimony from Dr. Bell that the defendant himself, as early as 2016, recently as 2016, said, I'm glad I got caught. I'm fearful I would have done something to someone. So this evidence was sufficient to allow the jury to conclude beyond that reasonable doubt that absent the civil commitment, the defendant was likely to commit another contact offense. Briefly, just to touch upon the defendant's second argument regarding the cartoon that was brought up in the prosecutor's closing, that cartoon was properly in evidence, so it was proper for the prosecutor to mention it. It was a brief remark, and so the Commonwealth would argue there was nothing improper about that.
What was the relevance of that cartoon?
The relevance was that it was, while the defendant was incarcerated, it was one of the multiple disciplinary reports that he received for engaging in sort of sexual violations. It had been referenced previously, I believe, during Dr. Bell's testimony, so the prosecutor was just referencing it again in closing, as it was already properly brought up in evidence.
Had the respondent not been incarcerated, there was no problem with the drawing, correct? I haven't seen the drawing, for the record.
Right, I don't think it was provided to the court. No, on its own, it's not a crime, but it was just provided, I think, in bulk of, to support the evidence, and it was already properly in evidence, so.
Even if it was sufficiently relevant to be admitted in evidence, it's still pretty tangential to the SDP issues, isn't it?
It's possible.
To play such an important role in the closing argument?
It's true, and I can't speak to the prosecutor's decision in utilizing that information during his closing, but I don't think we can say that there was any error in it where it was properly already in evidence. The jury had it, so. If there are no further questions, the Commonwealth will rest on its brief.
Thank you both very much.
Thank you.
The case is submitted. Our third case is 2022 P477 Commonwealth versus Tyler. And for anybody in the courtroom, I just want to say after this case, we will take a brief mid-morning break. And in this case, we have the pleasure of hearing from the Commonwealth first.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth, standing in for Assistant District Attorney Audrey Anderson, who submitted the brief on the Commonwealth's behalf in this matter, but has since retired. I'd like to direct the court's attention specifically to the motion judge's oral findings, where she gave her rationale as to why she was allowing the defendant's motion to dismiss. She cites basically three reasons. One of them kind of is melded together. The police report doesn't say that this holstered gun was pointed at anyone. That was one of the factors that she turned to. The Commonwealth would point out, as the defendant pointed out in their brief, that when you look at Commonwealth v. Langsavat, I'm not sure if I'm pronouncing that correctly, it talks about having to look at context. You have to look at the entire situation. And the gun doesn't have to be pointed at anyone. The weapon doesn't have to actually be pointed.
Do you think this I'm sorry to interrupt. Do you think this is a better or worse case for the Commonwealth, where in Langsavat there were shots fired in the air, right?
It's true. I think.
So do you think, even though they weren't fired at anyone, do you think that's a, if you will, better or worse, if you get my drift?
The circumstances in that case are much more severe. Clearly, you have shots being fired, much more serious, but it doesn't have to go up to that extreme. If you look at, there were a couple of cases I'd like to direct the court's attention to that my colleague did not include in her brief, but if you look at Commonwealth, it's a juvenile case, Commonwealth v. Oswaldo O., and I can give the site for that. In that particular matter, there were juveniles, 94 Mass Appellate Court 550. It was a 2018 case. In that matter, there was an interaction between some juveniles where they're in, I believe, a restaurant. The juvenile approaches the alleged victim, makes a comment about the hat he's wearing, and shows him a knife. He then leaves the restaurant. The alleged victim leaves the restaurant with a couple of friends. The juvenile follows them some distance, ends up in front of the alleged victim and his friends, again approaches them, makes a comment around, take your hat off if you don't want any trouble, and then opens his backpack and shows a knife again. There was no indication in that matter that the knife was shoved towards the alleged victim or raised up above them or anything like that, but that was still found to fit the statute, that was enough. Again, looking at a probable cause standard, looking at light most favorable to the Commonwealth. And if you look at the police report in this matter, which is what the motion judge had to go on, there are inferences in there that set up what the context of this situation was. When the police arrive, the defendant's car is parked in the middle of the road. He has arrived there because he received a phone call that his sister had been jumped. Clearly, a volatile situation. And when he arrives there, he gets out of the car, puts the gun on top of the roof, and makes comments. "Who jumped my sister? What are you going to do now? You don't know me." All of those could be, again, in looking in the context, could be perceived as threatening. The cases don't show that you have to say, "I'm going to shoot you." It doesn't need to be that explicit. Then another witness told the officers that they saw the gun, took it out of his coat, put it on top of the hood of the car, and said, "Don't make me slap out of you." And when that witness, I believe it was the uncle of the defendant, tried to take the gun from the defendant for safekeeping, the defendant grabbed it and put it back inside of his coat. So looking again at the entire context, the Commonwealth's position is that it meets the statute and that even though the girlfriend, this was another reason that the motion judge gave, that the defendant said he didn't intend to use it. Well, just because there's some evidence of that, that doesn't negate probable cause.
Would it make a difference if the aunt/victim heard it?
It potentially could, but there's no indication
Right, no.
that she did. And even if she did, that doesn't necessarily alleviate the fear. You know, if you're going down that road of possibilities, then that would mean a defendant can hold a gun to someone's head and say, "I'm not going to use it," and then that would be enough to negate probable cause. That would seem to not make much sense. You have to look at all of the factors, and in the factors, again, that the motion judge relied on, the cases just don't fall in line with that. Looking at that juvenile case, but then also looking at, there are cases where the alleged victim didn't even see a weapon. There wasn't even a weapon shown. The case that you look at, Commonwealth v. Delgado, 367 Mass 432 was a 1975 case. That was an armed robbery case, supposedly with a gun, where no one actually saw a gun, but given the context. And Commonwealth v. Hastings, 22 Mass App Court 930, that's a 1986 case. That was a rape case where the alleged victim felt something sharp in her back. There were comments made about a knife, but she never actually saw a knife. So given the circumstances and looking at these different cases, it can be enough just to show the weapon, given the context and what's being said, or it could be enough to imply that there's a weapon in certain circumstances to put the person in fear.
If the defendant, instead of placing the gun on the hood of the car, had given it to a friendly third-party police officer standing nearby and saying, "I'm doing this in order that no one misinterpret my lawfully possessing a gun," I assume you would acknowledge there would not be probable cause under that hypothetical.
Well, I don't know why the police would be there then. If he,
I don't know either, but
if he had if he had arrived at the scene and left the gun in the car, I mean, he can legally possess it. That's not the issue here. But he didn't. He didn't make that choice. He parked in the middle of the road. He got out. He put it up there so people could see it. It was a show, is the Commonwealth's position. It sounds like a show, a demonstration of potential force. He doesn't have to say, "I'm going to come at you with this."
Well, the judge appears to have read the facts differently, but your point, I take it, is that's not her role.
Again, looking at very, very low standard of probable cause, it's Commonwealth's position that the elements in looking at what was written in the police report, again, we're not looking at whether the Commonwealth would be successful at trial beyond a reasonable doubt. We're looking at, was there probable cause in the light most favorable to the Commonwealth's position that given these circumstances, there was. And that she did not, again, obviously, we would disagree with her assessment of those facts.
I think we get it, unless you have anything else.
No, hearing no other questions, I would rest on the brief. Thank you.
Thank you. We'll hear from the defendant.
Good morning. John Pavlos on behalf of the appellee, Mark Tyler. So just beginning with the last comment, he should have left the firearm in the vehicle. That would have been improper and illegal, actually, under our current law. There were two people in the car, including an infant. That was not a good decision, or would not have been. And perhaps removing a holstered weapon and putting it on the hood of the car didn't show perfect or good judgment. But what the trial judge, Judge Fentress, found within the four corners of the police report is that there were certain statements made that did shed light on that. And with all due respect, the standard, and this is for the record more than certainly lecturing you, of probable cause, we often sit as trial attorneys in the court filing motions, whether it's a McCarthy or Di Benedetto, and we hear the Commonwealth's refrain. It's an extremely low standard. It is, but it's still more probable than not. Simply,
I'm not sure a lot of people would agree with that.
well, if we say probable cause, we often use the 51% or these kind of colloquial attempts to all arrive at the same philosophical point on what constitutes probable cause. There are many interpretations one can make with this police report. There are arguments one can make therefrom, but it doesn't mean that there's more probability of the Commonwealth's interpretation. And what they're leaving out, I would say to you, the big kind of omission, if you will, is the intent. The case laws that, in fact, that they cite, this is not a fashion statement. These were my wife's, and they were the only ones I had access to this morning. So, including Commonwealth v. Chambers, Commonwealth v. Garassi. Those are on within their brief. There's also Commonwealth versus Thomas Musgrave, and that's a 1995 case at 38 Mass Appeals Court 519. Those all stand.
Just as a little point, not that anybody cares, I was a trial lawyer in that back in the Lowell District Court in 1991, and it was a shot across the bow argument that the judge bought, but yeah, clearly lost that one. Go ahead.
So I should steer clear of.
No, I was wrong, and I was wrong as a lawyer, and you were right that that's what it
Well, it stands for, and correct me if I get this wrong, but the holding, what I would propose it for is that the overt act with the intention of putting another in fear, and that's what they're missing here, because many of these cases.
Isn't the question of intent for the jury to decide ultimately?
I think so, and in other cases, I'm not often here on the appellee side, and I would suspect.
How's it feel?
Great. That you don't hear many cases in this posture that, standing here saying that the trial judge got it right. But here we have a report that has some of these factors that are often missing, and that is a statement from the defendant, an unholstered weapon. Any of the cases cited by the Commonwealth are not only unholstered weapons, but they're shooting into the air when a house party is letting out. There's a case that's been cited here for someone that was opening up the gas in a home knowing that people slept. These are overt acts. They're objectively perhaps menacing, and they're inopposite to this case. There are, again, not necessarily the best judgment in retrospect, but I think that the statements and the way that the police report is written, and just to be clear, I want to just put a couple of the sequences on the record. He told the police, that is Mark Tyler, that Warren Kirk approached him like he wanted to fight. That was one of the first things he said, as Warren Kirk came forward, and he said that that's when he put, in the next paragraph, he put his gun in the holster on top of the hood of the car, telling police what he said to the officer, because I know how my uncle is. Now, there could have been a longer explanation, but in the context of he was coming and I thought he wanted to fight, it's certainly a reasonable, if close to necessary, inference. And then according to the woman in the car, his partner, and the child they shared together, she's the one that introduced that he said that he was not going to use it. It's after that sequence that the uncle was coming, because the gun's already on the car when Uncle Warren says, he said to me, don't make me slap the out of you crap or whatever he said to him. There was an expletive in there. I'd suggest in none of these statements is there any reference to the firearm other than I'm not going to use this as these family and particularly Uncle Warren approach. Uncle Warren, when he spoke to police, did not express any fear. It didn't come up. He didn't say anything about it. So I would suggest that that also contributes to the court's analysis in the trial court, saying that it's objectively unreasonable for Ms. Rollins who is not in the direct kind of scrum, if you will, with Uncle Warren, to have that fear. There's some of these other issues about the car in the middle of the road. It's also important to note he's sitting there waiting for the police. He doesn't leave, and he says, you want to talk to them over there, pointing to his aunt and the other two, I guess, cousins. If you review the case law, I think, and with an eye to the intent, which was omitted, that part of the analysis was omitted by the Commonwealth, it is decisive here.
So although intent is for the jury, it's still something that needs to be there in the probable cause determination.
Yes, I would certainly argue that.
And so what you're saying is that viewing all of these facts, even in the light most favorable to the Commonwealth, that act of putting the gun on the top of the car is to disassociate himself with the gun. This gun is not going to be part of this interaction.
Yes, I guess one way to say it from my thinking is that the light most favorable to the Commonwealth does not allow them to negate express statements and actual evidence within the body of the police report. There are interpretations and arguments that can be made therefrom, but again, they should be more probable than not.
The Commonwealth may offer a hypothetical that, someone pointing a gun at you and say, but I'm not going to use it. I realize that's not the facts we have here, but it cannot be that a mere statement of an intent not to use the gun is enough to, in your words, negate the threat.
I think I would agree with that as an abstraction, as an intellectual, as a theoretical question, but here in the concrete facts from the case, he's removing it and putting it on the car in the holster. I think the court was very clear that was significant to her, that it was holstered. This is what we're going to see more of, whether it's in Massachusetts or throughout the country, as there are more legal firearms being carried by people in holsters. So, and police, we see police. There was a California case that had to do with, I think it was a Starbucks case where the workers said they were put in fear by police coming in with holstered weapons because it was in itself inherently threatening. And so that's kind of that extreme that we're talking about. Here, the law says that under certain conditions, you can have a licensed firearm and that you need to maintain it in a certain way. This was in a holster. He made explicit and physical efforts to remove it from someone coming to engage him physically. I believe that's what the trial court was focused on. I think that's what she said. She cited Di Benedetto. She applied the appropriate standard of probable cause. And so,
why was it unreasonable, though, why is it an unreasonable interpretation in context, and we don't know the exact timing, but if it's, who jumped my sister, what are you going to do now, you don't know me, slap the gun on the hood, why is it unreasonable, A, to infer intent to put the 10 people surrounding him in fear, and the reasonableness of the fear or the perception, I should say, of the aunt that this was an imminently threatened battery?
So what we do know is that police spoke to other people other than Aunt Rollins, I'll say.
Right.
And they did not express that. That it's she alone in the report that police say she seemed upset and she expressed fear that he was going to use it. But the Garassi case, which was cited by both the Commonwealth, I don't think for the appropriate proposition, but it's in our brief as well. And that's where you have the language, I think, that is important. And that is, what is essential is that the defendant intended to put the victim in fear of imminent bodily harm, not that the defendant's actions created a generalized fear of some other specified psychological harm in the victim. And I would argue that is the only possible interpretation that would allow a proper complaint, a complaint under these circumstances to issue, is to apply that standard, which would be improper. That is, this generalized fear that there's an inherent threat in a firearm, even if it's holstered and even if it's someone saying, you know, I'm putting this over here,
And I guess my question then is, why is it the only reasonable interpretation? I'm disassociating myself from this weapon as opposed to I am, as the prosecutor says, demonstrating this weapon. And what are you going to do now?
Well, again, we have a statement in front of the court at the time that directly belies that, and that is that I'm not going to use it. And there is no reference, even in the statements attributed to Ms. Rollins and Uncle Warren, there are no statements of any reference or gesturing with the firearm, or once the holstered firearm is on the hood of the car, referring to it or gesturing towards it. And I think that's significant.
Other than taking it back when the uncle goes near it.
There is Uncle Warren, there's a statement that he says, you know, and I was going to go take it for safekeeping. We don't know any more than that very brief statement. The police report, I believe you have, is the main part of the appendix for the appellee.
Well, it was his gun. He had the responsibility to keep control of it.
Yes.
I think we get it.
Thank you.
I want to note for the record, the court does not pass judgment on counsel's choice of eyewear.
I appreciate
The case is submitted. Excellent job by both sides. As I noted, we are going to take our mid-morning break. It is now, by my watch, 10. Thank you. We are back on the record for our fourth case of the morning. It is Johnson versus Settino, 2022 P941. And we'll hear first from Attorney Seiden.
Good morning.
Could you just tilt the mic? It's directional.
Good morning. May it please the court. My name is Stephanie Sedin, and I represent the appellant, Bruce Johnson. I'm here today to ask this court to reverse the trial court's finding that Mr. Johnson was at fault for terminating the engagement and to award the engagement ring and wedding band to Mr. Johnson. There was clear error for the court to find Mr. Johnson factually at fault because there was insufficient evidence in the record to support such a finding. Mr. Johnson did nothing wrong. The evidence in the record shows that the genesis of the dispute happened one evening when Mr. Johnson and Miss Settino had an argument. And Miss Settino stated, "I'm a good-looking woman, I can get any man I want," and stormed off to bed. Mr. Johnson was perplexed by this statement and looked at her phone. And in the phone...
Counsel, we have read
understand
the
the
brief,
facts.
so
Okay. So the point I'm trying to make is when you look at the recitation of those facts, the text message from Ms. Settino to Mr. Hinault, which invited Mr. Hinault to get together for playtime and indicated that Bruce was away, was the catalyst that caused Mr. Johnson to lack trust in Ms. Settino, and it was the crack in the foundation of his relationship with her.
Counsel, we're very familiar with the arguments you
Okay.
make in the brief. Why don't we start by sort of framing the questions before us? Because your brief talks about the application of the standards set in the Barker case. It talks about what you think the standards should be, where the court should go, et cetera. Just focusing on that for the moment.
Sure.
We obviously are an intermediate appellate court. To what extent are we simply bound by the Barker framing of the issues, and to what extent can we take you up on your offer to, after 7 decades or 6 decades, taking another look at the law on that? And before you answer, let me just note that Barker has at least 2 pieces. One, viewing a gift in this context as being subject to conditions, and the other is its invocation of fault, whatever that means, as a standard for the giver of the ring to forfeit, if for lack of a better term, his or her rights to get the ring back. So turning the floor back over to you.
Thank you, Your Honor. Our position is that if the court is going to expand the rule in DeChico v. Barker, which states that the donor gets the ring back unless the engagement is terminated based on fault of the donor, the court should be doing or including in the analysis a justification analysis, because under DeChico...
Yeah, but tell me if I'm wrong. You're now not saying we should reject or modify the case, which is beyond our ability to do, but that we should flesh out what the term fault means.
I think that's one choice that the court can take, and that's why both arguments are in the brief. If the court wants to take the conservative route and flesh out what fault means under DeChico v. Barker, it can do 2 things. Under the law and under the Restatement 58, which DeChico cites to, the conditional gift premise is there. And in comment C to section 58 of the restatement, it says that if you're looking at the true conditional gift law, that it is not a fault determination, it is donor gets the ring back when the condition fails. If you're looking at it in a more restitutionary context, it looks at fault on the part of the donor or justifiability on the part of the donor if the donee does something wrong, if the donor is justified in terminating the relationship.
What does wrong mean?
That's the question, and that's why I think we argue that no fault is the right approach. And
So
this-
I think to Justice Milkey's question, I don't mean to, maybe it wasn't the question. What's our path to that
The path to that, I think.
legally, where we can't overrule the SJC unless the 1975 no-fault divorce impacts it, but what's your thought on how we get there?
I have seen cases in other, like the South Carolina Appeals Court in Robinson did that. They made a rule that it was no longer a justification analysis, but a no-fault analysis with respect to terminations, and there was a higher level a Supreme Court, and this was the South Carolina Court of Appeals that made that decision. And I don't think the court would be overturning DeCicco v. Barker, but refining DeCicco v. Barker, because DeCicco doesn't talk about, doesn't get to the point of if the donee is at fault. DeCicco's law stops right at the language that says the ring goes back to the donor if it's terminated without fault on the part of the donor. And it doesn't require the donor to find fault on the part of the donee to get the ring back. But the path to saying no fault is that if you look at all the case law in other jurisdictions that has developed, Massachusetts law, as we've discussed, has not evolved since 1959 on this issue. And so...
At least in the appellate courts.
In the appellate courts. But there's only 2 Superior Court cases which touch on this, and they don't get deeply into it. And those are cited in our brief. I think New Jersey is a good jurisdiction for guidance on how the courts transitioned. They went from Mate v. Abrams was a case in New Jersey, which is cited in our brief, that used a justification analysis. And then years later, Arano v. Silver talked about the complexities of adjudicating fault and how it's so subjective, and they overruled Mate v. Abrams and Arano v. Silver, and it was a New Jersey Chancery Court case, adopted a no-fault rule, and then the Supreme Court of New Jersey adopted the Chancery Court's decision in Arano v. Silver. They applied it in a father-son conditional gift context, but they cited to Arano v. Silver, which was an engagement ring context case.
Getting back to Judge Brennan's question, do you think the 1975 adoption of the no-fault divorce statute provides a basis for us to conclude that the SJC would come out differently?
Yes, absolutely, Your Honor. I think that the genesis of the 1975 irreconcilable differences, no-fault legislation was to avoid exactly where we are today, which is 2 parties pointing fingers at each other saying, you did X, Y, and Z, and you did X, Y, and Z. And it's a public policy benefit to allow parties to break their engagements without fault, just like it is in the divorce context. And I think the appeals court could look at the legislation and I think it was Osborne, the case that was interpreting the no-fault divorces as guidance from the SJC where it would end up in this realm.
May I ask then, following up on what you just said, why is this not a legislative prerogative? Why are we creating this no-fault system in Massachusetts?
Because we're in a situation where the facts before you require it. Mr. Johnson is in an unjust situation where he is, and he paid a lot of money for a ring he gave Ms. SETTINO, and if you follow, the facts in the record don't support a finding of fault on his part, and he has lost that ring and the value of it. And so the facts present themselves today for the court to opine and figure out the law, because the way the law stands right now, it's incomplete. And I think justice...
Okay, but I want to tease this out, though, some more, because in your brief, you seem to assume that if were courts to move to a no-fault scheme, he gets the ring back. And I want to make sure I understand why you assume that, because part of the argument in your brief is that Barker is based, to the extent it at least looks at fault, is based on a more sexist view of the world from decades ago. If that's true, why is the initial part of Barker still correct, namely that it's a conditional gift? Wouldn't it be a, if you will, less sexist result to say that today it's not a conditional gift? If someone chooses to give an engagement ring, it's a gift. And we're not going to assume that there's a implied promise to get married. And that is the modern view. Or to put it more bluntly, couldn't it be argued that the whole idea of an engagement ring is sexist?
I disagree, Your Honor, in the shape, in the nature of the ring. I think it's hard to take the context of an engagement ring out of the idea of an implied promise, and it's a condition. And I think if you look at the conditional gift concept, it's something that it's given in the anticipation of a marriage, which is a promise to each other to occur. And the gift isn't complete until the marriage happens. And I understand what you're saying in that, well, maybe it's sexist in the modern view to view it that way, but I don't think our social mores and societal contracts have changed that much to say that engagement ring
We're only
isn't-
a little sexist.
I think that's moving it way too drastic of a, in my opinion, too drastic of a jump, because if you're going to say that an engagement ring doesn't mean it's given in the context of a promise to marry and that promise and condition to happen at another time, then what does an engagement mean?
Perhaps it simply is a representation of the status of the relationship. It's not a promise. It's to tell the world.
I hear what you're saying, but I still think it's pushing the law a little bit too far from where we are right now. And I'm not sure that's, I think there's a public policy on the law that protects the institution of marriage, and to eviscerate the act of giving an engagement ring as a promise to marry and a commitment to each other that is to be solidified and to be solemnized, I think that would eviscerate the public policy considerations that protect the institution of marriages, which is the reason why the irreconcilable differences on the law, on the books.
But doesn't that work, if it's no fault, then what's the significance of the engagement? Either side can walk away at any moment, and doesn't that contradict public policy? When you're saying, the preservation of of marriage, the relationship, but don't you take away all significance of the engagement if either side can walk away with no consequences?
I don't think so. I think what we're looking at is the value, like from a monetary perspective or from a practical perspective, the person that buys the ring, and in this day and age it may be a man or a woman, and gives that
Actually,
ring
that was true in Barker.
Right, yes, it was. But she didn't get her rings back. In this day and age, if a man or a woman gives another person a ring and a promise to marry, and that promise is broken, just from a restitutionary unjust enrichment perspective, the person that purchased the ring should get the ring back when the promise fails.
Well, in this case, there was a factual finding regarding what those rings meant.
Yes.
And what did the judge find those rings meant?
Judge found that they were given in anticipation of marriage and that they were conditioned on the marriage happening. And there was that, nobody's contesting that finding.
What about the wedding bands?
I believe the wedding band, Mr. Johnson, the court awarded Mr. Johnson the wedding band that he purchased for himself. So that's not an issue. The one on appeal is the wedding band purchased from Ms. Settino. And I believe that is even, should go back to Mr. Johnson as well, because that was purchased in contemplation of the actual marriage and to be given on a wedding day.
I mean, typically, wedding bands are exchanged at the wedding ceremony
Exactly.
itself. On the record here, how did the wedding bands get in the possession of Ms. Settino?
I believe it was their practice, Your Honor, that they, Mr. Johnson gave them to Ms. Settino to hold and gave her the receipt as well. That's my understanding.
I'm afraid your time is up. We appreciate the arguments you made on the prejudgment interest in the brief, and we'll now hear from Ms. Settino.
Thank you to the panel.
The lower court's decision to award me the engagement ring and wedding band was supported by detailed findings of fault which were not clearly erroneous and thus must be upheld. The case cited by the trial court in his decision dated January 3rd, 2020, denying Mr. Johnson's motion for summary judgment was DeChico. Am I pronouncing that correct? DeChico?
I have no idea.
DeChico versus Barker, wherein the court stated, it is generally held that an engagement ring is in the nature of a pledge given on the implied condition that the marriage shall take place.
If we can just interrupt for
Yep,
a
sure.
second. At least under the Barker case, that's why I call it the Barker case,
I'll call it that from now on.
it turns on the question of fault.
Okay.
And it seems that this judge analyzed the fault issue in terms of perhaps a couple of issues. One, that it's undisputed that the plaintiff here, Mr. Johnson, was the one who called off the wedding. Beyond that, there is the issue of the reason for calling it off, and there's some dispute in terms of this, and the judge, as you know, specifically found that Mr. Johnson's interpretation of the key text in question was inaccurate. You are correct that specific factual findings were made, but a lot of this would appear to turn on what does fault mean in this context. And there isn't a lot of law on this, and counsel has pointed to a couple of Superior Court cases that reason that it cannot turn merely on which party calls off the engagement, and there is at least some thinking among some judges that there needs to be more of a justification. And whatever else is true in terms of what standard we are stuck with as an appellate court, that there are situations where it may be that a wedding is called off without fault by either party, that the couple decides unilaterally or together that this marriage is not going to work. How are we supposed to approach that issue in this case?
Well, Your Honor, I honestly believe that the judge, Judge Glinney, he did his own justification analysis when he looked at the whole picture. And he wrote all the findings of facts, and he listened to the witnesses and made inferences from those witnesses, such as Steve Hinault, who's been my lifelong friend, who's married to my lifelong friend. And
Well, let's assume
okay.
that the judge's finding that Mr. Johnson's reading of the, I can't remember, is it text or an email?
Yeah, it was the
Text,
word play.
was inaccurate, and that's not clearly erroneous. Let's take that as an assumption
Okay.
for the sake of argument. But I would ask you to take as an assumption for the sake of argument that a fact finder could find that even though that reading was inaccurate, that it was a reasonable interpretation, a reasonable fear at least, based on what the text objectively says. If that is true, and assuming that it was the text that led to the unraveling of the engagement, how does that amount to fault?
Well, it's kind of ludicrous to call off a wedding because you read a text from a lifelong friend of mine and say, oh, the wedding's off. I would suggest that weeks before, while I was teaching, Mr. Johnson was with a realtor and looking at properties for when we got married. We were going to build a house in Hingham. We were looking for properties. So he would meet with realtor Kathy Lebrecht often. And during the depositions, now we're talking a year and a half after he called off the wedding, I found out during the deposition of Kathy Lebrecht that Kathy Lebrecht's friend went on my wedding website.
I'm sorry, is this in the record? Are these facts that are
Well,
found?
it was the deposition.
But are they facts that are found by the judge?
And is the deposition transcript in the record?
I would think that they are they? I have them here, but I don't.
It sounds like you don't know the answer to that question.
I'm not sure. Yeah.
Can I ask you then, on this question of fault?
Okay, sure.
I believe one of the judge's findings was not simply I think you indicated that to call off a wedding because of a single text is ludicrous. I believe that one of the judge's findings indicated that the plaintiff had started to notice how he was treated, and that was, sort of mistreated, right? And
Yes.
that was part of it.
Yes, and Mr. Johnson fabricated and lied a couple times during the court proceedings. And he lied about when he started dating after he called off the wedding, and that's why I was referring to Kathy.
Did the judge make findings on these issues?
Yes, he did. He lied in court, and this was in the trial court, about wanting a party at the resort where we were supposed to get married after he called off the wedding, and that's in the findings. And also, it should be noted that Mr. Johnson's affidavit in August 2019, he fabricated about the cupcake, that he heard a voicemail where Hinault called me cupcake. Steve Hinault would never use a term of endearment like that. We're friends. He's married to my best friend. They were going to our wedding. And during the
Is he on the, I noticed
they
part of the
never
record.
asked us
Ma'am, can I ask
about-
you a question? I noticed part of the record is the wedding list. We'll find his name on there?
Yes.
Okay.
Steve and Sue Hinault, yeah.
Could we pivot a little bit and talk about our earlier discussion with counsel about should we still be in a fault-based state on this, particularly with the enactment of the 1975 statute, which moved to a no-fault system in the divorce context? Speaking for the moment only for myself, there's something unseemly, for lack of a better term, about a trial court judge trying to get inside the human heart and decide what happened and why this engagement unraveled.
I totally agree with you. We should never have gone to Superior Court.
Why shouldn't we, at least apart from whether we're bound by the 1959 case, why shouldn't we move to a no-fault system?
Why shouldn't we move to a no-fault system? Well, the breakup of the marriage wasn't my fault.
It's possible that it wasn't anybody's fault, whatever that term means.
I think the honorable judge looked at all the facts, and he created his own justification analysis. He decided.
No, I think that's accurate.
Okay, I'm sorry.
Can I ask you a slightly
I
different question?
misunderstood.
That's okay. Can I ask you, if we were to say, as a court, that fault really isn't an issue, and that relationships are a little more complex than perhaps the court seemed to think they were in 1959, and it was nobody's fault, why should you get to keep the ring?
Well, if you're going to go to, it was a gift, and you're
Yeah, that's
going
that's the
to
question.
use
Yep.
that. Mr. Johnson gave me many gifts throughout a relationship. You know, he kind of swept me off my feet. You know, we flew to New York, we saw Hamilton, he bought me jewelry, he would buy me many bags. Each time he bought me a gift, he'd give me the receipt.
And he gave you the receipt, as I recall the record, with the engagement ring, which
Yes,
I thought was a little
and the
unusual.
bands. And
Right.
when the day that we got the ring, or ordered the ring, he handed me the receipt. I have the original receipt, like all the other gifts that he gave me. And that was in court.
So
That-
what does that mean to you?
Well, consider it a gift. But I want it on the record, I did not cheat. It's a matter of principle. I was traumatized. My life imploded. I was a teacher. I had 60 people from my school coming to the wedding. We were putting them all up for 2 days at the resort. We had all sorts of things. So when he called off the wedding and said I was cheating, I was devastated. My life imploded.
Can we, time is starting to get short.
Okay.
Can we turn to the wedding band itself?
Yes,
Because
the
Mr.
wed-
Johnson's counsel has not placed a lot of focus on the wedding band, but given that wedding bands are typically exchanged at the wedding itself, I'm having a hard time understanding the rationale of the judge and saying essentially because the band was in your possession, you get to keep it.
That wedding band was also, there was supposed to be 2 wedding bands, okay? So we got his wedding band and my wedding band. You put the engagement ring on, and that wedding band locked in, so you couldn't lose the engagement ring. When we got married, we were going to get another band for the other side. It was like a 2-prong, I guess, but they were loose.
And is this all in the record?
Though the bands are, I don't.
Okay. Given that time is short, do you want to address the prejudgment interest issue? Specifically, why the Sterilite case is not controlling?
Sure. I first want to start, I think it's a bit of a red herring. They're trying to distract. When his motion to alter amend, when that was denied, they gave me the money for that.
I'm confused. You're saying the prejudgment
Yeah, they already
interest-
paid me the interest. So my reason is this, I think they're thinking, well, they'll give me the money because that was 9 months ago. If they waited till today and I won, that would be 9 more months of interest that they would have to give it to me. So it's sort
So,
of like
but
a
the
red
question-
herring. Why are you
I mean-
bringing it up? Because you already gave me,
So the question, though, is why would you be entitled? Usually you get prejudgment interest because that's money that you would have otherwise had access to, whereas here, it's not so much. This was just teeth, not just, but this was teeth. And so.
right,
where
and I
you
still
hadn't
don't have
put-
my teeth.
Okay. Well, so where you hadn't put out the money, or in some ways you didn't lose access to the money, why do you get to have interest on that?
Well, I think Johnson incorrectly stated that the court lacked the authority to award me prejudgment interest of the $20,000, and the judgment entered on February 9th, 2022, because I did not lose money during the case, and when no such money was lost, no prejudgment interest can be awarded because it would be a windfall. And MGL-C 231-6C applies a different set of rules. Section 6C states in part that in all actions based on contractual obligations, which that was, correct?
Okay, but the amount of damages that the judge awarded, put the interest issue aside, did the amount of damages cover the cost of the dental work?
I'm still in the process, and the cost of living has gone up, so it will probably be more money. But I'm in the process of it. Yeah.
But in any event, the money, at least the damages portion, was paid.
Yes, and I'm still not done, so I don't know.
Oh, just to try to clarify, was the award of prejudgment interest paid or not? Because typically when one appeals, money judgments are stayed.
Yeah, he paid the prejudgment interest. He already paid it. That's why I called it a red herring. It's a distraction for the rings, which is, for me, it's a matter of principle about the rings. But yeah, that was already paid. I don't know why they even put that into their brief, because when they wrote their brief, that money was paid.
We may need some clarification on this point,
sorry.
but if so, we will issue an appropriate procedural order. I'm afraid your time has expired.
Okay.
And the most interesting case is submitted. Thank you both very much.
Thank you.
Our next and final case of the morning is a care and custody matter. It is 2022 P933. I want to remind able and experienced counsel that the case is impounded, so please, no names. We can refer to all of the parties here, except for DCF, by status. And before we begin, I just want to go over the process. I expect it was clear from the order, but as I understand it, mother and father will be splitting their time. They will have the full 15 minutes. The child's lawyer will have 5 minutes to present his position on the child's motion, and DCF will have 15 minutes.
Good morning, Your Honors. Stephen Rosenthal for the appellant mother. May it please the court. First, with respect to child's motion, mother shares child's position, and basically, mother contends that child has been consistent in wanting to be with mother throughout this litigation. If you look at my principal brief, and I believe it's pages 29 to 31, I've summarized evidence of the child's bond with the mother and the child's repeated requests to be with the mother and or to visit mother more frequently.
So, perhaps this is best asked to the child's attorney, but given the evidence of that in the record, it's confusing that the child was on the other side for a while, but we can get clarity.
I can't explain that. I didn't try the case. But we do know that as recently as just before the trial, the adoption worker spoke to the child, and the child told the adoption worker, I want to be with mom. So I don't know whether there was some confusion. This is I think she was 6 years old at the time of trial, so there may have been some confusion there. But I think the child has been relatively clear throughout this litigation that she prefers to remain in mother's custody.
And just on a factual point, your brief states that the pre-adoptive couple expressed openness to an open adoption
It was a
agreement.
pre-adoptive mother, a single mother, Your Honor.
Sorry.
And she expressed interest in an open adoption agreement, and she also said that that the child would suffer emotional harm without contact with the mother, which is actually quite the opposite of a finding that returning the child to mother would be harmful to the child. There was no evidence of that in the record. Now, if I can move on to Mother's argument, what we're asking you to do, Your Honors, is to take a de novo look at Mother's alleged waiver of her right to counsel. Mother contends that she was denied her right to counsel and that, therefore, denied due process and is entitled to a new trial.
Can I ask, hopefully, maybe a quick question, but it's my impression, and it may be in the record, that the judge was not in the courthouse. Do you have any insight on that? That the mother was in one place, the clerk was in the courthouse, and
The trial was conducted over Zoom.
I know it was over Zoom, but
I
in
don't
terms
know
of
whether-
the, yep.
Frankly, I don't know whether the trial judge was in the courthouse, but there was a clerk present, so perhaps there was some mutual meeting point. Okay?
Yeah, can I just ask a, if you will, structural question, which is, a lot of the cases you cite on right to counsel are in the criminal law context. And you seem to make an assumption, perhaps accurately, that those cases get imported into the care and custody context because that's, the care and custody cases draw on the criminal law precedent. And I just want to test that because there's a rich case law on, for example, what it takes in the criminal law context to waive. And there's a rich case law on there being structural error if there was a violation of the right to counsel. What is your, I know adoption of Rory, but other than that, which dealt with a slightly different articulated issue, what is your best case that all of this jurisprudence gets imported? Or is it like, say, the civil commitment context or the SORB context where some of criminal law gets imported and some does not?
Well, first of all, there is case law, Your Honor, and I can't cite chapter and verse, but I know it's in my brief, that says that the loss of custody of a child could be just as much of a deprivation of one's personal liberty as a criminal conviction. But if I can refer to a case on which you sat yourself, Your Honor, the In re Gabe case, there was a case, and it's also cited in my brief, where it predates the Haltowanger case, which I cited ad nauseum in my briefs. But In re Gabe said that where a parent had been found to have waived right to counsel, but there was no certification filed and there was nothing on the record or no findings on the record to indicate that the parent had waived the right to counsel, then that was improper and it was a deprivation of the right to counsel.
Is Gabe cited in your brief?
Yes, it is, Your Honor.
And that was unpublished or published?
It was a published decision, and I believe you sat on the panel that heard the case.
I'm sure I didn't write it. I would remember it more clearly.
Can I ask you then, in that vein, I mean, clearly there was no certificate of any sort, there were no findings made on the record by the judge contemporaneously. What impact, if any, does the judge's, or do the judge's findings 8 months, I don't recall exactly, later on the motion for new trial or for the post-judgment relief have on that? In other words, can we consider those in the same way as if they were made contemporaneously, or do they really fall under a different category from your perspective?
I think it falls under a different category, Your Honor, because of the rule that I cited, SJC Rule 310, Section 3, which says before accepting a waiver, the judge has to do certain things. And the rule is clear, unequivocal, and using the plain meaning of that rule.
But there was some relaxation during the pandemic, because as in this case, for example, getting a person to sign a waiver is a little bit difficult when the mother's not physically there. Similarly, if the judge is not in the courthouse, actually a written certification becomes a little more difficult, and the SJC, I think, has looked in some of these cases.
That's one reason why I kind of overlooked the certification as being part of my argument that there was a deprivation of the right to counsel. In this case, and as interpreted in this court's Haltowanger case, which, by the way, SJC denied further appellate review, this court said, no matter what the inquiry is, when assessing whether a mother is competent to waive right to counsel, it has to be on the record and there have to be written findings. And one can question, one can argue whether the colloquy was adequate in this case. Mother is quite certain that it wasn't, but there were certainly no written findings. And sort of backfilling after the fact in denying the motion to in denying the motion for a new
By the
trial.
way, you can keep talking.
Oh, thank you.
For the moment, ignore the red light.
Thanks very much. So the point is, making that finding after the fact does not help. The rule says before accepting the waiver. And if I can continue, the judge, in denying the motion for a new trial, basically said, well, the mother waived her right to counsel by her conduct. And I would point you to the Means case, Commonwealth versus Means. It's a SJC decision, which is cited in both my brief and reply brief. And there are three elements. There has to be, the mother has to, or the parent has to, I'm blanking, hold on a second. The mother has to basically fire counsel for not a good reason, and there has to be, you know, a situation where the judge specifically warns the litigant that if she continues with her dilatory behavior, then she won't be allowed a new counsel. There was no evidence of dilatory or oppressive or bad behavior by mother towards counsel in this case. She didn't agree with either one of them. She said neither one of them will contact me or pay attention to me. And in this particular case, mother had good cause for discharging her last attorney. But the last thing I want to mention, and I appreciate being given the extra time, is that I would ask the court to look at the transcript, particularly starting at page 42 through page 51. And that transcript is the transcript of the hearing that took place on March 31st, 2021, which was about 5 months before the trial started. That was the point at which mother was told, okay, I'm going to split the baby, and I'm going to appoint, I'm going to remove Attorney Martino as your attorney, but keep him on as standby counsel. That's not an issue as far as Halterwanger is concerned. That doesn't solve the problem. But in that section that I just referred to, first of all, mother asks for her original attorney, who she said was doing a good job. She didn't fire her. The attorney withdrew because of maternity leave.
Hey, can I interrupt you for a sec? Because we are starting to get short of time.
I appreciate that.
I understand you're arguing that something akin to structural error applies. But can you give an example, and one example will do for now, of how counsel would have made a difference in this case? So that, you know, assuming you had to show prejudice, give us an example.
It would require me to go outside the record in some instances, but what I can say is that it was mentioned during that March 31st hearing that motions in limine would have to be filed. Mother had no idea what a motion in limine was, and in fact, the judge said counsel need to get together and figure out what information needs to be redacted from the exhibits. Mother never got involved in that, and all sorts of information came in during the trial, including a statement by an unidentified psychiatrist that mother had the emotional maturity of an 8 to 10-year-old. So an attorney would have objected to that hearsay information. There's one example.
Okay. I think we're going to have to turn it over to the father. For the record, I've got adoption of Gabe here, and apparently what we said was that structural error as such is a criminal law concept, but then we said it provides a useful analogy.
Correct. Thank you, Your Honors.
Good morning, members of the panel. May it please the court. Nicole Paquin on behalf of the appellant father who is here today. First, regarding the child's emergency motion to withdraw her brief, father supports the motion. The child is now 8 years old. That is old enough to have and articulate an opinion regarding her relationship and her desires with her parents. I can't speak as to whether the child has changed her mind, but children do change their minds. That has been known to happen, and the wishes of the child must be considered by this court according to adoption of Garrett. It's not determinative, but they must be considered. So if the child's opinion today is that she does not want father's rights to be terminated and she does want to visit him, then father supports the child's motion. And the allowance of the motion would certainly not be prejudicial to any party. I'd like to focus my remaining time on the choice of the permanency plan and the trial judge's abuse of discretion in punishing the permanency plan offered by the father, the paternal aunt, for not coming forward as a resource sooner. The driving factor in making custody determinations is the best interest of the child. When a juvenile court judge is faced with competing permanency plans, the judge's role is to meaningfully evaluate both plans. It's an even-handed assessment, paying close attention to the suitability of each resource. So in this case, it was the foster mother or the paternal aunt. Instead, here, the trial judge punished the paternal aunt for not coming forward sooner. There are many reasons why a family member might not come forward as a potential resource immediately. They might not want to interfere with the reunification process. They might live out of state or out of the country and feel it's not appropriate. They might not want to invite the department into their lives, especially if they have children in the home.
What was the inference drawn by the judge? Regarding the delay?
The judge drew the inference that as a result of the 3-year delay, as the judge framed it, that the child spent 3 years in foster care and that was not in the child's best interest. And those findings are findings 97, 98, 105, and conclusion of law 38. The judge made 14 findings about the paternal aunt and 1 conclusion of law. Of those 14 findings, 3 have to do with the delay and none have to do with the suitability or her ability to actually parent the child. Here,
Was part of it, though, that given the delay, we just don't have enough information on this person, and at a certain point, in the best interest of the child, we got to get to the end and figure this out, no?
Well, the judge did not make any findings that she lacked information. The judge didn't make any findings as to which plan was in the best interest of the child. The judge's conclusion was that the court finds the department's plan appropriate and does not endorse father's plan. That's conclusion of law 38. There was no...
Isn't implicit in that the judge found the plan best served the interests of the child?
I don't believe that it's implied. There's no indication that the judge considered whether the paternal aunt would be a good resource for the child.
Isn't part of the judge's concern here was the paternal aunts allowing the father access, at least at a time in his life when the judge thought that should have been controlled?
That was certainly a factor. The judge did mention that, but that was somewhat of a separate issue. The judge repeatedly mentioned that this issue of the delay. Yes, the judge was also concerned with the access to father. As a result of that incident where the child saw father during a visit with the paternal aunt, the visits were suspended, not permanently, but they were suspended. And the paternal aunt did testify that she would comply with court orders as not giving access to father in the future. But here, the judge seemed very focused on the timing, and I'd like to direct the court's attention to adoption of Hugo, which was actually relied upon by the child, where the Supreme Judicial Court applied the best interest of the child standard to two competing permanency plans. In that case, it was also an aunt and a foster parent. And the department there learned of the aunt's interest in adopting the child 2 years later. So here we have a 3-year so-called delay. In adoption of Hugo, it was 2 years. And the judge in that case correctly evaluated each resource's ability to meet the child's needs. The judge here did not do that. There were findings about the foster mother, but not findings about the paternal aunt's ability to meet the child's needs.
Was there evidence regarding the reason for coming forward 3 years later?
So the evidence regarding that is that the child was placed in 2017 into foster care. The aunt came forward in March 2020. She had known that the child was in foster care. She came forward when she learned that the goal was adoption. Up until that point, the paternal aunt understood that the father wanted their mother, the paternal grandmother, to have custody. Unfortunately, she had cancer, and so she decided not to come forward at that time. When she learned from father that the child was facing adoption, she did come forward.
But the judge made no findings concerning all of that, the reasoning.
The judge, she did find in finding 98 that the paternal grandmother was diagnosed with cancer and was too ill to care for the child. This court finds that despite knowing that child was in foster care and knowing that paternal grandmother was too ill to care for child, paternal aunt chose not to pursue custody of child, and she remained in foster care for 3 years as a result. So that was finding 98. I would like it to be noted, though, that and I realize that I'm out of time. I will be brief. In these cases, the department has an obligation to inform family members about the goal of adoption and about a child being in foster care. Here, the department delayed. They did not complete this process known as a family find until June 2019, which was a year after the department's goal changed to adoption and 9 months after the department first reported to the court that it would complete this process. So in June 2019, the department completed this process, but somehow the paternal aunt was not included. The record is clear that paternal aunt was never notified by the department. Had they, in June 2019, when the department finally completed the family find process, notified the paternal aunt that the goal was adoption, perhaps the paternal aunt would have come forward as a resource then. We'll never know. But she was deprived of that ability.
Okay, I need to ask a question, and that is, if you assume hypothetically, and this for the moment is a pure hypothetical, that the panel were to accept the mother's argument with respect to the right to counsel, so that that matter had to be remanded, is there any reason not to resolve the father's appeal as it stands today?
I believe the two are so interconnected because the father's first priority, while of course in a perfect world he would love to have his daughter, his first priority is to have his daughter with his sister. And so I think where his preferred permanency plan is his sister, the paternal aunt, it would be expedient to have this matter remanded along with mothers if the court so decided, so that both could be heard again, because the father today is asking for remand for further proceedings on the paternal aunt, most especially. So where the two are so involved, And the issue would be, where should the child, who should have custody of the child? I believe we should not resolve fathers today. It should be remanded.
Hearing no further questions, I think we're going to have to leave it there, and we will now hear from Child's Counsel.
Thank you. As to any other points that I did not raise, I'll rest on my brief.
Thank you.
Good morning. May it please the court, Matthew Price on behalf of the child. The question that came up earlier during Mother's presentation, in terms of the position initially taken by the child, involved speaking with trial counsel, meeting with the child, and at the time of trial counsel was aligned with DCF in evaluating the situation. An appellee position was the appropriate position to take. In light of that, recently, in terms of meeting with the child, she indicated a different position, and that is what initiated the motion that I filed with the court. The reason for filing it was in trying to accurately portray the new position and stay loyal to her wishes, and given the short notice, that seemed to be the appropriate path to take. And in light of that, I did not prepare an oral argument as far as the issues covered in my brief.
Let me just explore something you said in your papers, which is, as a fallback position, your client supported visitation with the mother. And as I noted earlier, there was also a mention in the mother's brief of the possibility of an open adoption agreement. Could you say more about the prospects of that from your perspective?
The indication to me was that more visitation would be favorable. Therefore, a remand to the lower court to review that would be supported by the child.
If there is no mandated visitation, at least if the pre-adoptive mother's position does not change, there will be visitation, correct? Am I misreading that?
My understanding is 2 visits for mother and no visits for father.
That is my understanding as well.
Sorry. Well, maybe, I don't know if this clarifies it better. Child's position now would be seeking more visits as an alternative.
But in terms of the possibility of an open adoption agreement, I mean, that's frankly not something we, the panel, needs to consider further in resolving the issues the parties have put before us, at least most of the parties. But occasionally, and I've been doing these cases a long time now, very occasionally one sees a case where the possibility of a negotiated agreement might be in everyone's interest. And this is potentially one of those cases. So as we, the panel, does our job resolving the issues that have been presented to us, we would encourage the parties to keep talking about whether or not there might, because I mean, you can tell from our questions that, we find the mother's right to counsel arguments non-trivial. On the other hand, the prospects of a third termination trial is very daunting and not one that, frankly, I would wish on anyone. So, again, we will do our job, but we would encourage the parties to continue to talk. That's all I'm going to say on that score.
Thank you, Your Honors.
Thank you very much. We will hear from the department.
May it please the Court, Richard Salcedo on behalf of the Department of Children and Families. First, with respect to Child's Counsel's motion to withdraw her brief, although obviously outside the record, it's the Department's position that certainly the child's position should be respected, and the Department does not contest the child's right to withdraw the brief at this time. However, the Department would express some concern about child joining with appellants at this stage, late stage, and where the child had not filed a notice of appeal, and we don't feel that.
Can I just say, I say what the child has filed is more a statement of position than advancing any new legal arguments.
Right. Well, as to the request for a remand to revisit the issue of visitation, we would oppose a remand on that basis. As we detail in our brief, the trial judge's order is well supported by evidence. Judge's order regarding visitation, I should say, as to both evidence is well supported by the evidence presented at trial and by unchallenged findings of fact. In particular, I would point the court to the court's findings 51, 57, and 80 with regard to mother, and finding 39 with regard to father. And further, the child can always seek to review the visitation order below, and there are avenues for the child to do that on their own. As the court has pointed out, the record also indicates that the pre-adoptive mother is open to furthering contact with the mother in this case.
Can we turn to the right to counsel issues?
Certainly.
As you know, there are different ways one can waive the right to counsel. One is express waiver. Could you first deal with that in terms of, was there any express waiver here given the length and nature of the colloquy?
I would say that the mother explicitly waived counsel, and she also waived counsel by her conduct in this case. She was appointed 3 different attorneys over the course of these proceedings. Her second attorney took over in June of 2018 and represented her for more than 2 years. This case was actually originally scheduled to go forward in 2019, and there's a transcript of the second hearing in that proceeding that the department has provided to the court. There's no issue mentioned of mother having any issue with this particular attorney, and the record shows that the attorney was prepared to go forward on mother's behalf.
So can I ask, why does that then not speak to just the opposite of what you're suggesting, that the mother has the ability to work with an attorney, worked with an attorney for 1.5 years, for some reasons didn't work out, got what really was a second attorney, because the first one really seems to me you can't count since she checked out given family issues. She has the second attorney, and she tries to articulate reasons as to why, and I think she does some, but the attorney doesn't really talk to her, doesn't visit her house, doesn't really know anything about me, things of that sort. Why are we at a RAISA, which and again, if I'm saying it correctly, which as I recall, was about 8 lawyers in, on what is effectively the second lawyer. How do you reconcile those differences?
I mean, after more than 2 years of being represented by this attorney, Mothers, then it becomes, in September of 2020, the attorney says that I'm filing a motion to withdraw at Mother's request. Mother's only explanation at that point is that she's been unavailable to me. She doesn't make a showing or a claim that her attorney has been unprepared or that the attorney is incompetent. She further says on the record, I just want another attorney. And
at that point, she's not asking to represent herself. She's asking for another attorney.
Correct. And the court allows the motion to withdraw and proceeds to appoint another attorney. And at that point comes, I believe, apparent to the court that Mother is seeking to have a particular attorney appointed for her, and the court points out that she doesn't get to do that. And in fact, the attorney she was hoping to reappoint was not available in any event. But the court picks an attorney from the available list, and without even meeting with that attorney, Mother objects right off the bat. And the court at that point informs Mother, you can't keep choosing or firing an attorney, and if you do, the court presents her with the choice of proceeding pro se or proceeding with the attorney that I have.
Your sense is that wasn't a little premature at that point? I mean, worked with a lawyer for a year and a half, had a problem. I don't really like this guy. I've seen him in the hall. Well, it's either take him or go pro se. I think there's a little premature at that point to make that.
I'm not sure. I think she's.
And I'm paraphrasing, obviously. And I understand the difficulties, and I just want to make it clear. I mean, especially when you're working on Zoom and with someone who is frustrated and angry at times. So there are certainly some difficult circumstances for the judge, but
I think pointing it out at that point, I think that the court could at least, because Mother also, I think at that point said, well, I can fire my attorney as many times as I want. And the court just wanted to sort of disavow her of that idea and say, you don't get to do that. And after that exchange with the judge, Mother does say, okay, I will work with this attorney.
Can I jump, if you wouldn't mind, to a place that's a little bit more problematic, at least for me, which is, we're all, assume, agree that the waiver has to be knowing, intelligent, voluntary, and explicit, right? And as I read the transcript, and I looked at page 44 after the breakout room, which was about 2 minutes, the mother says, I'm going to keep Attorney Martino. And the judge says, Attorney Martino, would you be willing to accept this case as standby? How do we go from I'm going to keep Attorney Martino to Attorney Martino, would you like to be standby?
I don't recall.
Given all the context.
Right. Mother on...
and then she follows up by saying, okay, I'll go pro se, I want him on the sidebar. But I'm going from, I want to keep Attorney Martino. Seems to be pretty much an unequivocal statement, I want a lawyer. And the judge's response in the very next line or line thereafter is, Attorney, would you be willing to accept the case as a standby?
Mother multiple times says that she will go pro se. Right. And that...
Isn't that the very definition of equivocation? I think I want to go pro se, and, excuse me, the language, but then she says, okay, I'll go pro se, in quote, for shits and giggles. Is that really a knowing, does that indicate any sense of the magnitude of the decision that she's making whatsoever?
I mean, I think there's, it's a bit of a confusing exchange because Mother keeps sort of interrupting the trial judge, and the judge needs to, had to keep redirecting her in order to sort of continue the inquiry. But I think the inquiry was adequate to establish...
Let me ask this on voluntariness. At the very end of that brief discussion, Mother, you guys are giving me the short end of the stick. I need a new attorney. I don't need him at sidebar, I need a new attorney. I can't even get a fair trial. How is that in any way indicative of a voluntary waiver of a fundamental right?
Well, prior to that, a number of times, she agrees that she will work with the attorney who was acting as her standby counsel. It also would point out that standby counsel very actively represented her throughout the 4 days of trial. At the first day of trial, mother failed to show, and trial counsel appeared on her behalf and filed a motion to continue.
How about the motion in limine example that mother's counsel used as an example of actual prejudice?
Well, I don't believe, I mean, the evidence of mother's unfitness was overwhelming in this case. I'm not sure that a motion in limine would have made a difference.
May I ask, I'm sorry, go ahead. May I ask a question, because I'm not familiar with the juvenile court, very familiar with how things work in the other trial courts, but is it traditional when conducting a colloquy, especially on a waiver of counsel, to swear the person in? Does that not happen in juvenile court?
I'm not sure, Your Honor.
Okay. Sure. We can agree that she wasn't sworn in any way. There was no formality of any sort to this process of waiver of counsel.
I'd have to go back to the transcript here. I'm not.
We haven't yet touched on the mental health issues and that component of the waiver. You make the point in your brief that someone can be mentally ill and still knowingly waive right to counsel. You're correct on that. But in a situation where there are, the opposite isn't necessarily true, that just because you're mentally ill, that means you can waive. So with all the red flags here with regard to her capacity to waive counsel, isn't it a problem that the judge didn't address that issue either overtly or in any findings?
Well, we have the court's decision denying mother's motion for new trial, and the court does talk about that, and specifically notes that the court finds that mother's outbursts, tangents, and inappropriate behavior to the evidence is not, mother does not find that it's to be evidence of incompetency or that she did not understand what the court was asking.
But you'll agree she didn't conduct any real inquiry on that, notwithstanding
contemporaneous inquiry.
Right, contemporaneous. Notwithstanding there's some indication that the mother's on medication, because she says, well, I'm told if I take my medications, I can see my kids, right? But doesn't say, are you taking any medications today? Have you had any alcohol? You're sitting at home. Have you used any drugs? Nothing to really ascertain the mother's mental capacity or competency in the moment of the waiver. And I don't mean to, I'm saying that in a very, I suppose, pejorative way. Let me put it this way. Can you point to the best piece of information that would suggest that the judge explored that even in the slightest during the course of the interaction?
Well, the court, I think, does focus on the points that are regarding probing sort of what the mother's understanding is about the consequences of self-representation, about the magnitude of the undertaking, the disadvantages of not proceeding with appointed counsel. All of those things are touched upon in the colloquy, and there's indication that mother understood. Mother does respond, how do I file a motion? How, can I retain private counsel if I want to? All of
She
those.
kind of says, how do I file a motion to get my kids back, right? Which is not quite the same as how do I file a trial motion in a legal sense, right?
Right.
Okay.
Just one last question, at least for me. What is the department's position, if any, on the legal question of the extent we are to import criminal law concepts into this context? And specifically, I'm thinking of what it takes to waive the right to counsel and the question of whether the mother has to show any prejudice, if at all.
I think the courts in these cases, in the child welfare context, have regularly used, by analogy, the principles from criminal cases regarding waiver of counsel, and I have no reason to think that it shouldn't continue to apply to our cases as well.
I do have one last question. Just your position on the findings that were made on the post-judgment relief, whether those findings have the same force, if you will, as contemporaneous findings made, whether in writing certifying something or just orally, that I find this person to be engaged, to be understanding, et cetera, and freely and voluntarily waive the rights.
I think they should be considered and given considerable weight, because they are it's sort of memorializing the court's reasoning, its rationale of what the court was thinking at the time of the hearing, the reasoning why she believed that the waiver was valid.
Right. I mean, ordinarily, we'd give substantial deference to the judge's findings. So the judge is sitting across. My question is, does it have the same, should we give it the same level of deference when it's 8, 10, I don't recall exactly, months later, as opposed to I'm sitting across from the person, seems to be, or I see her on the video screen right now, she's engaged, she's looking me in the eye, she appears to be responsive to my questions, et cetera, et cetera.
I mean, it's obviously not the same, but, where this was the same judge who heard the evidence, who observed mother at trial, was also the judge who decided the motion for new trial and made, 16 specific findings, clearly explaining her reasoning. I think that would very much carry some weight.
Thank you all very much. A challenging case that has been ably handled by counsel, and equally important, handled with appropriate sensitivity. This concludes our session. The case